The Union government has released a revised Personal Data Protection Bill, now called the Digital Personal Data Protection Bill, 2022. What are the 7 principles of the 2022 bill? Firstly, usage of personal data by organizations must be done in a manner that is lawful, fair to the individuals concerned and transparent to individuals. Secondly, personal data must only be used for the purposes for which it was collected. The third principle talks of data minimization. The fourth principle puts an emphasis on data accuracy when it comes to collection. The fifth principle talks of how personal data that is collected cannot be stored perpetually by default, and storage should be limited to a fixed duration. The sixth principle says that there should be reasonable safeguards to ensure there is no unauthorized collection or processing of personal data. Seventh principle states that the person who decides the purpose and means of the processing of personal data should be accountable for such processing. What are the key features of the Digital Personal Data Protection Bill? Data principle and data fiduciary. Data principle refers to the individual whose data is being collected. In the case of children less than 18 years, their parents, lawful guardians will be considered their data principals. Data fiduciary is the entity, individual, company, firm, state etc., which decides the purpose and means of the processing of an individual's personal data. Significant data fiduciary. Significant data fiduciaries are those who deal with a high volume of personal data. The central government will define who is designated under this category based on a number of factors. Such entities will have to appoint a data protection officer and an independent data auditor. Rights of individuals. The bill ensures that individuals should be able to access basic information in languages specified in the 8th schedule of the Indian Constitution. Right to consent. Individuals need to give consent before their data is processed, and every individual should know what items of personal data a data fiduciary wants to collect and the purpose of such collection and further processing. Individuals also have the right to withdraw consent from a data fiduciary. Right to erase. Data principals will have the right to demand the erasure and correction of data collected by the data fiduciary. Right to nominate. Data principals will also have the right to nominate an individual who will exercise these rights in the event of their death or incapacity. Data Protection Board. The bill also proposes to set up a data protection board to ensure compliance with the bill. In case of an unsatisfactory response from the data fiduciary, the consumers can file a complaint to the Data Protection Board. Cross-border data transfer. The bill allows for cross-border storage and transfer of data to certain notified countries and territories, provided they have a suitable data security landscape, and the government can access data of Indians from there. Financial penalties for data fiduciary. The bill proposes to impose significant penalties on businesses that undergo data breaches or fail to notify users when breaches happen. The penalties will be imposed ranging from Rs. 50 crores to 500 crore rupees. Financial penalties for data principal. If a user submits false documents while signing up for an online service, or files frivolous grievance complaints, the user could be fined up to 10,000 rupees. Who are exempted? The Centre has been empowered to exempt its agencies from adhering to provisions of the bill in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, maintenance of public order or preventing incitement to any cognizable offence. Why is Digital Personal Data Protection Bill significant? The new bill offers significant concessions on cross-border data flows, in a departure from the previous bill's contentious requirement of local storage of data within India's geography. It offers a relatively soft stand on data localization requirements and permits data transfer to select global destinations, which is likely to foster country-to-country trade agreements. The bill recognizes the data principal's right to post-mortem privacy, withdraw consent, which was missing from the PDP Bill, 2019 but had been recommended by the Joint Parliamentary Committee, JPC. How has India strengthened data protection regime? In August 2017, a 9-judge bench of the Supreme Court in Justice K.S. Pottaswamy, RETD, V's Union of India unanimously held that Indians have a constitutionally protected fundamental right to privacy that is an intrinsic part of life and liberty under Article 21. What data protection laws are there in other nations? European Union model. The General Data Protection Regulation focuses on a comprehensive data protection law for processing of personal data. In the EU, the right to privacy is enshrined as a fundamental right that seeks to protect an individual's dignity and her right over the data she generates. US model. There is no comprehensive set of privacy rights or principles in the US that, like the EU's GDPR, addresses the use, collection, and disclosure of data. Instead, there is limited sector-specific regulation. The approach towards data protection is different for the public and private sectors. The activities and powers of the government vis-a-vis personal information are well defined and addressed by broad legislation such as the Privacy Act, the Electronic Communications Privacy Act, etc.